Duluth area from Canada.
Yeah,
So, we'll see.
indeed we shall. Well, good morning. I'm Buck Malick, a citizen member of this St. Croix County Zoning Board of Adjustment and I reside in the town of Hudson in St. Croix County, Wisconsin. Today is August 22 of 2024. It's 8:30 in the morning according to the clock on the wall, and we are in the St. Croix County Government Center in the county boardroom. These are the time and the place that were announced and published in the newspapers for the August meeting of the St. Croix County Zoning Board of Adjustment. So it's my honor and duty to call our meeting to order. I will ask the other members of the Board of Adjustment and the zoning staff to identify themselves and use their microphones right now, and we'll go around the room for that. Mr. Peterson?
Dave Peterson, Town of Kennington, citizen member.
Joe Miller, Town of Hammond, citizen member.
Greg Taljan, St. Croix County Supervisor, District 14, representing Aaron Prairie, Richmond, and a little bit of Warren Township.
Dave Nickham, Town of Baldwin, citizen member.
Steve Smart, alternate to the board.
Jason Cheezick, Community Development Director.
And we have Julie Peterson taking notes and generally keeping order here. And we have an unnamed gentleman in the sound booth making sure that the audio video works. I will state for the record that it is my belief that this meeting was properly noticed and published. There are laws that pertain, and I believe that they were followed. But if there is anybody in the room who has a reason to think they were not properly followed and this meeting is therefore not legal, please speak at this time. So we will deem that to be legal. We have minutes, board members, from our meeting of July 25th, our last meeting, and we have been provided a set of those. Does anybody have changes or edits for those proposed minutes? If not, we will deem them to be approved in the way that they were provided to us and to the public, for that matter. We have a sign-in sheet for those people who might want to speak, and we will proceed to deal with the two matters that we have before us today. Mr. Cheezick, are you leading off on the Baldwin Airport?
Yes. Thank you, Mr. Chair and members of the board. So the Board of Adjustment heard a conditional use permit request to expand the Baldwin Airport camping, and that from 17 units to 42 units back on January 25th, and they made a decision on March 28th, 2024. As part of that decision by the Board of Adjustment, they asked for community development staff to provide an update at the July Board of Adjustment meeting. And so at the July meeting, our staff did provide a written update. Much of that update was coming from the owner, Kerry McCauley himself. But the Board of Adjustment, because there were still several conditions that had not been met, asked for a subsequent update on today's meeting. And so as provided to you is a letter confirming violations on the Baldwin Airport property that we determined at our August 12th site visit. That was between Abby Coffin and myself. And so with that, we've got some documentation here of the violations that we have. So you can see they've got their units over here off to the left where they were designated for the 42 campsites. but we've still got units along this east property line here. And you'll see the one here at the very end definitely looks like it's being used like a camper unit, but it's like a pontoon with living quarters built on top of it. We also have some concerns that the lot line might be close to the edge of the driveway here. So these might actually be parking across on different property owners' property. So, and I will just add that about 2 weeks ago, we got another written complaint from the town of Hammond on the Baldwin Airport properties that they were not following up on the conditions that the Board of Adjustment had granted back in March. So I'll get more into that as well. So this is looking, so they're kind of concession stand area and where they gear up and that for the skydiving is off to the left over here. This would be looking almost due west at the the south end of the campsites. So all the campers are over here off to the right. This is where there's supposed to be that drive lane for EMS to go around the campers. You can see that there's nothing even started in that for that drive lane there. Just another picture and that kind of showing where the campers are in relation to that. There is no gravel drive lanes in between any of the rows of campers. This is looking to the south and that towards County Road J. Again, we got a lot of parking over here. We didn't have any conditions directly towards that, but there is concern that they could be on a neighboring property. This is that unit that I said was at the north end of those camping areas. You can see that they've got power hooked up to it. Definitely looks like somebody could be staying in there. You are correct, Mr. Chair. Sorry for the glare here, but there was a bunch of skydivers dropping right when we were out there. This is the north end of that gravel drive. You can see there really hasn't been anything added here, but there is a slight extension, but there is no gravel drive that goes around the west side for sure. So all the campers, the supposedly 42, are off to the left here. And so that's the pictures that we had from the site. Now I'd like to just walk through the decision document that the Board of Adjustment had. I'm not going to repeat the findings of fact, but I'm going to go right to the conditions and the ones that we believe the applicant is not complying with. There's a total of 7 conditions that we believe that they do not comply. The first one here, we believe that the 42 sites, they're probably exceeding that, especially with those 3 units that are not within the designated campground area. When we were on site, I will make note that we didn't see any campsites along County Road J, but we were there on a Monday, so it was not a weekend or a holiday. Number 2, the applicant shall provide at least a 12-foot gravel road around the perimeter of the campsites for emergency services. That has not been met as shown by the pictures. And then condition number 4, there should be no parking allowed on the emergency access roads. Just the way those cars were on the south side there where I took and said that the campers were on the right, you know, there was cars blocking like a thoroughfare there if they were going to have that drive. So and then the ones that are parked along the east side, and then that pontoon boat with the storage is also parked on the gravel. So we believe that they would not be in compliance with condition 4. We did not get too far into condition 5 to see whether or not every travel trailer had a current license or tab, but I can speak pretty confidently that at least 1 or 2 of them over on that east side did not. But we did not go through and walk amongst all 42 campers, checking that out. So that one may or may not be. Yep.
Am I understanding you correct that at
Yes.
least one
Yep.
does not have is not currently licensed as a trailer?
I can guarantee that, yes. Yep. The site plan shall include campground water, sanitary, and electric hookups, and that we have not gotten a complete site plan on this site. Now, I wish I could have got some photos of it. But condition number 12, the junk items in violation of section 15.353, junk shall be removed or stored within a building by June 28th, 2024. After we were on site, again, there were lots of skydivers coming down, probably 20 of them, and they were getting pretty low in the air. And so we didn't want to walk out there where they were dropping. However, we did drive up 200th Street, which is just to the west of the property. And as we drove up 200th Street very slow, and that we could see that there was significant amounts of junk and that on the north side of the property. As far as the tree removal and the vegetation piles, a lot of the area has been regrown in that, or there's a lot of new growth that blocks whether or not those piles were actually removed or not. So condition number 13 is questionable on whether or not they complied with that one. Part of our update back in July was that Bolt Plumbing was out and did an inspection of the Baldwin Airport property sewer system right here. And we still have not received the report, and that in community development determining that the system is sufficient in capacity. And then provision or condition 16 here, the applicant or operator of the campground shall construct and operate in conformance with St. Croix County zoning ordinance. We believe that they have not been doing that mainly because of the setbacks to the units and to the property line. So that summarizes the 7 conditions that we believe they have not complied with the Board of Adjustment on. And with that, I would take any conditions, and then I do have a suggestion for the board on how we could proceed.
Questions, board members?
Yeah, what, on your parking along the cornfield there, what's your basis for thinking they're possibly violating the property line?
Just going off from our county GIS website, and being that this was part of a quarter, it looks like the lot line comes down here pretty close along the existing drive.
Okay, so nobody's actually physically walked it then?
Has not been surveyed, no.
Okay, and now for any other campsites, aren't they required to have a parking plan with the vehicles or not?
Right, that's part of those conditions, and that of condition number 16, and that we haven't had, so. Yep.
Okay, so
And
they're,
so here, I mean, is where this aerial a few years ago, but now that drive, I would say, probably stops here. That's where I had that photo with the north end of the campground, but there's nothing here in that comes around on this side at all, so. And then the garbage, or the junk, and that is still in this location, right there.
that's all I got.
I think that pontoon thing was parked right up against the cornfield there almost, wasn't it? That would be pretty good indication that it's probably infringing on the property.
Correct. So we would recommend that the property owner would have to have a survey, and that in order to verify these setbacks if they can't prove to us where the line is. So to verify compliance.
What, did I miss something? What was the complaint from Town of Hammond?
The complaint from the town of Hammond was their continued operation and that not complying with the conditions. That's a summary, but it was in writing. It was on our complaint form, so it was a formal complaint that I had gotten when I went to their plan commission meeting. Like I said, it was 2 weeks ago. This past Monday was the day.
Other questions, board members? Well, it appears that the site is not compliant with various ordinances as well as the terms and conditions of our new update of the permit. So I guess this has gone on for quite a few months now, and it's time to take some decisive action. We're either going to enforce our ordinances and enforce our conditions, or we're going to not allow them to have any more campers than the previous number, et cetera. call the sheriff with respect to trespassing on the neighbor's property, on and on.
Yep.
What do you have in mind for possible enforcement actions, Mr.?
So as I provided in that, Abby and I wanted to make sure in that we did our due diligence again. I think the owner has been notified several times, but this letter and that gave the applicant 30 days to correct any of the violations. So that has September 16th, 2024. So we would recommend that the board plans for and schedules public hearing on the revocation of the conditional use permit for your October Board of Adjustment meeting, because if we wait till the September 16th date, we still have to provide 2 weeks of notice for proper notice, and so that would miss the September board meeting, and October, then you'd have more than enough time. They have the letter, that would almost be, well, it would be a whole another month extra, actually, which would be in conformance with our compliance procedure. So we would suggest that we have that revocation hearing in October.
Why don't you just put on your enforcement hat and issue them a red tag and shut down operations based on violation of the previous permit?
Because the ordinance says that they gotta come back to the Board of Adjustment for that, so. Right now, it says that, and that any conditions that are deemed revoked have to come back for the Board of Adjustment.
But if we don't revoke the conditions, then they are in violation of that 1984 or whatever permit. That only allowed like 5 camping sites, if I remember right.
Right, but there's been a subsequent approval of it for the 42 sites, so, so I mean, if there was a condition that had to do with a different, condition besides the number of campers, then it's possible that we could go back and enforce on it. But as far as like the junk removal and, plumbing plan and stuff, and that is unique to the 2024 BOA.
It
Case.
seems to me that this owner is not taking our ordinances seriously. I don't see that anything has been done in the direction of complying with the conditions. Did they formerly have, when you first started enforcement, were they having camping in the 5 sites out on the front?
I believe when they were applying on that through the county, and that this is in the fall of '23, yes, they had camping out there, and that was some of the complaints and that we had from the town at that point, so.
So maybe they've stopped that, but when you visited the last time, it wasn't a day when those 5 sites might have even been in use.
Right.
So we can't even say that they've done a single thing to comply with the terms of their previous permit or the conditions that we put in place in order to expand them to 42.
Correct. Yep, that's what I would say, that they have not been complying.
Mr. Peterson whispered in my ear, so I'll say it out loud for the record, that perhaps we should bring in Corporation Council and see if there isn't something that can be done before our October meeting.
You can schedule it for the September meeting too, if you want, but you just might overlap, and you might just have to take and cancel that agenda item if you'd like to take and address the matters faster.
I'm thinking we should. I mean, this seems like we might be dealing with a scofflaw here, as Bob Raleigh of Troy Township used to say. A scofflaw, which apparently some old English term that means people who pretty much ignore the law. And if that's the case, we've got to be decisive, and we've got to back the staff on this and not leave them hanging out on the end of a limb here, not knowing whether we are going to support them. So we could schedule it for September. Apparently the staff doesn't want to be more aggressive than that, and we don't want to push them, I guess, where we don't where they don't feel legally
Well,
comfortable.
We're hoping to make amendments to the ordinance if approved by the committee and the county board, and that to allow staff to automatically revoke these conditional use permits so that you guys don't have to hear them, and that we can pursue enforcement faster on them. But that's not currently how our ordinance is reading, so, yep.
Apparently Corporation Council is on her way to visit us, and you'll probably have to go over some of the same stuff again, but that's okay. It'll be a briefing. Thank you for joining us. So for the record, Corporation Council has entered the room, and if you'll just introduce yourself on that microphone, Heather, for the record.
Yes, I'm Heather Amos, the Corporation Counsel for St. Croix County.
Okay, thanks for breaking into your day to join us here. We've got a situation that I assume you're generally familiar with, but we can get an update for you. And we haven't taken any votes here as a board, and we may not do that, but speaking for myself, it appears that we are dealing with a situation in which there's been non-compliance for a period of at least a year, and there appears to be very little effort, if any, to comply with the conditions of our new permit, our new conditional use permit, which the applicant asked for approval to increase the number of camping sites to, I think it was to 47, and we approved 42, not allowing the 5 out along County J. But that was all conditional, and it appears that the applicant has just taken the good and left the bad behind. No road. There seems to be parking that's trespassing on the neighbor potentially. There's junk that hasn't been removed. We're not sure that the brush piles have been cleaned up. We can't tell without getting close to them because of the regrowth of surrounding vegetation. No site plan has been provided. No letter from the plumber showing that the septic system is adequate to serve 47 sites. I think I mentioned the trespassing on the neighbor's property appears because it's a cornfield and they're right and one of the units at least is right up to it. One of our conditions was that no camping sites, that they would all have to be currently licensed, a state of Wisconsin trailer license. That was so that so we could have reasonable assurance that in the event of a fire or some other incident, the fire department would be able to hook onto those trailers and move them, that they would have, viable tires and undercarriages and wouldn't be all skirted with concrete blocks or something that would create a public hazard of significance to the people in them. So we're facing all this non-compliance with the old permit and the conditions of the proposed new permit, and existing in an atmosphere in which the present ordinance requires notices and time. And Mr. Cheezett has just told us that he has sent a letter from his department on August 15th indicating that they would make a compliance check on September 16th. We have a meeting in September scheduled for the 26th, 10 days after the date of that proposed compliance inspection. And the one question that we have is whether we could schedule this matter for action at our September 26th meeting. And I at least, and I have, as I say, I haven't submitted it to the board and asked for a motion or anything, but I at least am thinking that I'd like to have schedule it on the 26th, get out whatever notices for hearings and so on are pertinent to that, if it turns out that there's something in our ordinance that impedes us from actually taking action to revoke the license on the 26th, then we'd carry it over to the October meeting. But with every intention to act as quickly as we can, whatever business this airport properties conducts is primarily seasonal, you know, although they have a very long season, but if we let them get through the period where they can generate revenue here without our taking action, we lose a good deal of our ability to enforce our ordinances, it seems to me. And so time appears to me to be of the essence. Besides that, if they're going to put in a road, they need to put it in during the construction season. If they're going to put in sewer, water, electricity lines, et cetera, it needs to be done before the ground freezes and so on. So there are, you know, just shooting from the hip and making this up as I go along, there are important reasons to be moving as quickly as we can with fairness to all under the law. We continue to have complaints, so it's not academic. And we continue to have concerns that relate to public safety. So it is not academic, and it is not vengeful on the part of the Board of Adjustment. There's a legitimate public concern, it seems to me. So, you know, feel free to ask the questions you need to ask, but there's a starting point.
And so is your question on that September 26th meeting whether we provide the adequate notice that you would want to proceed with revoking their conditional use permit?
That's one of the options,
The
yes.
original one.
Yep.
And so Chapter 15 does address that in Section 15.550.9.c. When a conditional use does not continue in conformity with the conditions of the original approval, the Board of Adjustment may terminate the use after a public hearing and notice to affected parties. So there would have to be a public hearing, which you would have on that September 26th date, and then the affected parties would just need to have notice provided to them as to what it is that the board may consider on that date.
So starting from today, August 22, if we got the notice out in the course of the next week and we sent a certified letter or whatever it is we do for notices, a first-class letter or whatever it is, we could indicate that potential remedies to be taken on September 26 might include revocation of the license, and we would do the hearing notice to the applicant, to the occupant of the property, would be contained within that letter. Notice to the public would be published with the publication for our September 26th meeting. Am I summarizing that right?
Yes, and I would just clarify with Mr. Cheeseth that that is enough time.
It is enough time in that to do the public notice, so. Anyway, I won't be here for the September meeting and that, so that's one of the reasons why I was pushing it back to October and that, but our staff can be prepared in that to do it on the 26th of September, so.
You're confident in your staff, are you?
Absolutely.
I mean, sorry, I didn't mean that in an ironic fashion. I know that some of them are new, and therefore you have
We'll be
training to be conducted and so on.
We'll be prepared and we'll have done another site visit very close to that September 26th meeting and that so that we know what the current state of the property is for your meeting.
Potentially, you would want to, before you leave on your, you would want to help your staff draft some sort of a revocation, findings of fact, and conclusions of law to be filled in the blanks with whatever turns up on the September 16th inspection visit?
Yes,
Am
that
I
would help our staff. before I
understanding
leave.
that?
Yep.
And will you be available on September 26th, Ms. Amos, to help us if we need legal advice?
Yes, I am available and I have it on my calendar.
Oh, great. Well, board members, what have we missed? Go ahead and fill in whatever questions
I
you've
had a
got.
thought about that. I know when Jason said they were out there before, a bunch of jumpers were landing, so in our notice, would we want to specifically let them know that you need to be out in that property, and if they have to suspend their jumping while you're there, so be it. But, yeah, I'd rather have you be able to get in there and verify everything so that we don't have what-ifs there.
Okay. Yep, we'll make contact with the property owner to make sure that we can get all the documentation needed.
Well, if the property owner doesn't cooperate with you in receiving your contact, then you will just do what the law requires and send letters, and it's a horse on them if they can't make the appointment and so on.
Yep.
Yeah, they can't be allowed to control the agenda by simply evading meetings with you.
And we have
If-
access to the property with the CUP conditions that you provided, so it allows us access. So, yep,
Now, if we revoke the permit, it would not, or would it? Would it suspend jumping activities?
no, and that the conditional use permit was only for the campground expansion, so, yep.
And the existing permit, it does not permit parachute jumping. That is an unregulated activity. Am I understanding that correctly?
I don't know. I'm not an expert on parachute jumping. So.
Well, you might ask for legal counsel on that then. If we revoke the permit, what gets ended? What gets terminated that they are currently doing? Does it include the aircraft operation? Does it include the parachuting onto the premises? Or does it only end the camping, so that the campers would have to be removed? Then there would be no continuing to charge for camping on the site.
The camping for sure, and we'd have to look at the original approvals for any of the skydiving activity to see if there was a violation of that condition that would be linked to the camping.
Okay, thanks. I think we're thinking along the same lines. Mr. Peterson?
Also, my thought on the septic issue there, would we also want to specifically state some remedy if that's not confirmed then?
Okay.
Yeah, good point. We certainly don't want a biological hazard out there from a septic system that's not functioning properly. How shall we frame this up for a motion by the board? Probably along the lines of scheduling this for our September 26th meeting and providing all the pertinent notices for the possibility of a revocation of the previous permit and a suspension of approval of our proposed new permit. Is that the way we ought to go, Mr. Cheez-It?
Yep,
you
sounded
think?
good, Mr. Chair.
Okay, somebody, the record's got that, so Julie, when you come to transcribing it, you'll be able to take the words from that, I guess. Somebody want to make a motion to do that, as I just described it?
I'm going to abstain from this vote because it's in my township.
And you already have a position on this, do you?
I have the town's position, but, yeah, that's why I'm going to abstain.
Because you have a bias that's based on having taken a previous position on this permit.
Correct.
All right, I got you, yeah.
I will so move the suggestion.
I'll second.
Okay. All right, and we note Mr. Miller's abstention and, or recusal is a better word, I guess. And we still have a quorum, of course, so further discussion or debate about this motion? Are you clear what you're voting on? Okay, all in favor of the motion, vote aye.
Aye.
All opposed, vote nay. It's unanimously approved that we will proceed in the order that was previously outlined. Thank you for your work, Mr. Cheez-It. I know, or I can guess that compliance actions are among some of the harder aspects of your job. They are for us too. But rules don't make sense unless they are enforced against those who are violating the rules, because everybody else in the world is relying on those rules and complying with them. We cannot be seen to favor scofflaws. I believe that concludes our action with respect to the Baldwin Airport matter. We have another matter on our agenda. And I think that we're in a somewhat ambiguous position with regard to public hearings. I probably closed the public hearing but back a couple of months ago. But now we have a letter from the DNR that we need to get into the record. So I think I need to reopen the public hearing. And if we reopen the public hearing for one thing, then we need to have it open for the possibility of anybody else in the room who wants to speak, including the applicants. So that's what I'll do. And then I think, Mr. Cheese, that you're planning to read the DNR letter into the record as they requested?
Yeah, Mr. Chair, so the second agenda item is a continuation on the after-the-fact variance request to permit an accessory structure within the 200-foot setback to the ordinary high water mark pursuant to section 17.36, period G, period 5, period C, 1 of the St. Croix County zoning ordinance for the Anderson and Wapnows in the town of Troy. And so on July 25th, the Board of Adjustment had the public hearing. Staff provided a thorough staff report with some pictures of the site. At that time, they closed the public hearing and they asked staff to do some extra follow-up. And so part of that extra follow-up was to do more pictures of the site about other potential spots where this building could be built in a compliant location. So I've got pictures in that for that. And then on August 19th, so it'll be Monday, we received the letter from the DNR, and I can read that in right now. It is fairly lengthy, so bear with me. So it is addressed to the St. Croix County Board of Adjustment, Department of Land Management and Records, Planning and Zoning, Surveying via email. Dear board members, the Department of Natural Resources has received the hearing notice for the August 22nd, 2024 public hearing concerning the after-the-fact request submitted Ellen Anderson and Robert Wapnow to retain an accessory structure garage located within the 200-foot setback from the ordinary high water mark. Per the information provided by the applicant, the department does not believe the applicant can demonstrate meeting all three statutory criteria for granting a variance. The Snyder v. Waukesha County Zoning Board of Adjustment decision, and then it's got the link or the citation in parentheses, made it clear a circumstance or a desire of the applicant is not a factor to be considered when deciding variances. The applicants constructed an accessory structure which could not have been authorized in the location and does not meet the criteria to be located within the 40-foot bluff setback. Further, the State versus Winnebago County decision, and then it's got the citation in parentheses, established that economic loss or financial hardship do not justify a variance. As the board reviews these variance requests, please keep in mind that the applicant has the burden of proving that their request meets all of the statutory requirements for the granting of a variance for each variance request. That is, the applicant must prove that they will suffer unnecessary hardship if the provisions in the county's shoreline zoning ordinance are literally enforced. The Wisconsin Supreme Court has made it clear that proof of unnecessary hardship by itself does not entitle an applicant to a variance. All three statutory variance criteria must be satisfied in order to grant a variance. It may be possible that the applicant will provide additional evidence at the hearing which may change the conclusions listed below. Unique physical limitations. The applicant must demonstrate that unique physical limitations, wetlands, steep slopes, streams, rock outcroppings, or special conditions of the property exist that prevent compliance with ordinance regulations. The physical limitations must be unique to the property in question and are not generally shared by other properties in the area. There are not unique physical limitations on this lot that other properties in the area do not share. No harm to public interest. The applicant must demonstrate that variance will not result in harm or be contrary to public interest. The board must consider the impacts of the proposed project as well as the cumulative impacts of similar projects on the interest of the neighbors, the community, and the general public. These interests are listed in the purpose statement of the ordinance for the St. Croix Riverway zoning, include promote the public health, safety, and general welfare, reducing the adverse effects of overcrowding and poorly planned shoreline and bluff area development, preventing soil erosion and pollution and contamination of surface water and groundwater, preserving and maintaining the exceptional scenic, cultural, and natural characteristics of the water and related land of the Lower St. Croix. Unnecessary hardship. The applicant must demonstrate that if the variance is not granted, an unnecessary hardship exists. The applicant may not claim unnecessary hardship because of the conditions which are self-imposed or created by a prior owner. For example, building a home in compliance and then subsequently constructing a deck without a permit. Courts have also determined that economic or financial hardship does not justify a variance. When determining whether unnecessary hardship exists, the board must consider the property as a whole rather than just a portion of the parcel. Hardship does not exist for conditions that are self-created or self-imposed. Please note that these comments are regarding the Lower St. Croix National Scenic Riverway zoning and shoreline zoning regulations only and do not reflect applicable erosion control, waterway permitting, floodplain zoning, or other department regulations. It is the responsibility of the Board of Adjustment to assure that the statutory standards for the granting of a variance are met. The standards help to ensure protection of the public interest, including the preservation of water quality and fish and wildlife habitat along lakes and rivers. Wisconsin's navigable waterways are held in trust for all people to enjoy. The shoreline setback is important to protect the water quality, natural scenic beauty, and the fish and wildlife habitat of Wisconsin's waterways. The department appreciates your commitment to Pierce County's water resources and protection of public interest for future generation. Thank you for the opportunity to provide comments. Sincerely, Kate West, Shoreline Team Supervisor.
Do you think she meant to say St. Croix County's water resources, or have we become responsible for protecting Pierce County also?
There's several inconsistencies in this letter, Mr. Chair. The structure also meets the 40-foot bluff line setback, but it does not meet the 100-foot bluff setback. And also the Pierce County issue, and then also in the top portion there, she's referencing the shoreline zoning regulations and not the Lower St. Croix Riverway regulations. So I believe it's just a form letter that they use to comment on several requests similar in this nature.
Do you suppose that what she meant about the not meeting the 40-foot setback had to do with the color?
It could be.
That's one of the requirements, that it be earth tone or summer vegetation color if it's located within the 40-foot setback zone.
Well, so the structure meets the 40-foot bluff line setback, but she's saying that this structure is within the 40-foot bluff line setback, and it is not. But to be less than 100 feet from the bluff, you need to meet the criteria about the color and stuff like that. So instead of within, it should have been at the 40-foot bluff line setback.
I see it. It's in paragraph 2. Yeah. I just
Correct.
wanted to correct my copy there. Thank you for reading that.
And with that, Mr. Chair, would you like to see the new pictures that staff took on the site from August 16th?
Well, let's see first if board members want, I don't know, to talk with you about this letter, as I've just done. If they understand what you're saying and why, or anything you can help with. Dave, did you have a
Yeah,
question you
do
wanted
we,
to ask?
do we know, did she visit, or members of her shoreline team supervisors, did they visit this site?
I think they did on the day that they were here for the boat ride. They said they were on their way to look at some sites in St. Croix County. Did you get a chance to go out there too?
Did I personally? No, I did not.
Oh, I did. And I was surprised at what I saw. I expected to see some really mature trees, maybe some old growth or virgin trees or something. What I saw was a mixture of trees all the way from buckthorn to some big white pines, a couple of them, red pines. Most striking thing I saw was a sign about 20 yards from where the driveway meets Black Bass Road, a little sign on the right side of the driveway that says, "Parking here." It was a look, I didn't walk up to it, but it looked to me like it was a plywood sign that said, "Parking here." And next to it, on the right side of the road, was a space that was practically level, about the size of 3 cars. I said to myself, well, that'd be a good place for a garage, actually. If it's good enough for temporary parking. So, did any of the rest of you visit that property? No. No, okay. You do have to drive on a private road, Black Bass Road. So I felt a little insecure about that. I met one resident who was coming out, and he kind of looked at me. I showed him my big orange, sign that we're equipped with. It says we're on official business. But yeah, I was surprised. And I also noticed, I had wondered what were the properties like in that neighborhood. Going to the uniqueness point, she says these are not unique physical limitations. Well, it turns out that the properties on either side, upstream and downstream from this property, also have hills and gullies, and that was I saw that all over the neighborhood, but particularly on the two on either side of it, where you could put a garage was severely limited by the topography of all of those lots, particularly the two on either side of them. So I think I have to agree with her. It's not a unique physical limitation. And then when I came back, I looked at the topographic maps, and I could see, yes, the lines are pretty tight, indicating steep slopes up or down in some places. But that place where they had indicated for parking is a place where the topographic lines are pretty far apart, meaning it's relatively gentle slope.
Also, I'm not sure I got this right, if I remember right from the last meeting, but did a neighbor call attention to this?
The neighbor, yeah, on the downstream side, the south of it, I believe, is where we're told, yeah. Any other questions you want to ask Mr. Cheeset about this before he goes into his pictures there? Okay, go ahead.
All right, so Kelly Becker on our land use team was out with Mike Wozniak on August 16th to the site again to take some more follow-up pictures as requested by the Board of Adjustment on the July 25th date. So here's one, and that you'll see kind of what it describes up here on the upper left-hand corner. So this is a picture, and that looking at the downslope side of the carport. So this here is looking down the driveway, so standing up towards the house or the carport, looking out towards the road. Okay, this here would be the house to the north from their property. This would be potentially an area that would be meeting the 100-foot bluff line setback, which would also mean that they would be meeting the 200-foot ordinary high water mark setback in this area. So this kind of shows you where there's a couple trees. Same picture, just a little bit different, and that a little bit farther towards the water. So that's looking north. This is an image looking to the south. So looks like there's a pine there and maybe a popple. So another picture of the north side, because that's where we had talked about. Here's some of the trees. So it looks like a red pine, and then the popple here on the south side. Some more trees that would have to be removed if it was put on the south side there, a clump of 3. Here is the retaining wall that was made out of cinder blocks that failed as part of the construction of the garage. So the water from the roof, would come right off from here. It's almost right up to the drip line, and I'm sure they were getting water behind that wall. There you can see how it drops off. Remember, one of the factors for moving the garage down in this area was their sewer system is right down in this area, so that would be one of the things that they would have to avoid.
Do you think the sewer line runs under that garage site?
I don't believe so. I believe it goes across the backside. So, yep,
To the south of the building?
to the south of the building, just barely. Yep. From the best we can tell. I mean, without digging it up, and that, it'd be pretty tough. So this is also on the south side of the driveway, so the sewer system is back up in here over on the right. So this would be kind of that area. This was that red pine and that some of those other photos were of. This would be that clump of 3 trees. So this is kind of just a panned out view of that spot. This is looking at that same south side of the driveway. The carport's in the background up here. So here's that pine. That clump of 3 trees is right behind this pine. So this kind of shows you the area. The sewer system would be back here, almost back by that blue tarp area. This is more looking in that from the carport or the house down at that same area. So the same group of 3 trees, the red pine here, the poplar.
Did you say there's a carport here? I thought it's a garage.
Well,
It's got walls on 3 sides, and they simply haven't installed the garage door yet.
yeah,
And-
and it's a
and the
garage and that, so I believe their
testimony of-
application calls it a carport, or our staff have called it a carport. But yes, it is the red garage type building with the concrete floor.
And Ms. Anderson said they intended to put a door on it, a garage door on it.
They did at the July meeting, yep.
Yeah. Thank you.
So this is another picture and that from the north side. So the other pictures that we had were more down here, a little bit farther down the driveway. This would be probably right at the 200-foot setback area. You can see the house to the north is in the background here. So a little bit heavier tree cover right in this area. But you can see there's also room down here that's got more grass availability. And that's the end of our pictures that we had from August 16th.
Did she have one taken from right on Black Bass Road showing that area that I saw with the sign that said park here?
No, she didn't have that.
No. Did she mention it to you? You didn't go out there yourself,
I
right?
was not on site, no.
Yeah. I didn't take a picture either. Okay, questions about the pictures?
Yeah, this might be a silly comment, but I didn't see a lot of old growth. Now, they don't log these off, do they, next to the river? Or do they?
Well, they could if it were set back far enough. Otherwise, I guess one could cut. The general prohibition on cutting is you can't cut trees if they are greater in diameter than 4 inches diameter at breast height, unless they are diseased or dead or a hazard. I think those are the 3 criteria. But if it's not, gee, I don't know, I suppose if it's more than 200 feet from the water line, one could log.
Yep.
Do you happen
And
to
then-
know,
yeah,
Jason?
Yep.
No, it might
Basically,
not be
within a slope
economical.
preservation zone or from the bluff to the river, and that would be the area that'd be protected. So, yep.
There you are. Yeah, generally you'd have to pay the tree company to cut the trees. They wouldn't pay you if you've only got 3 of them or something like that, you know. Any other questions for Mr. Cheezett on that? Okay.
Okay.
Okay, well, since the hearing is open, does anybody in the room want to speak some more? The applicants want to, now that you've seen the DNR's letter, do you want to dispute some of its points, for instance? Yes. Sure, okay. So we'll hear from Mr. Lopno and Ms. Anderson.
Well, something I failed to mention, the origin story of the, we call it a carport, it's garage, is our cars were exposed to the elements, of course, and then, I don't know if you remember, on April 1st, 2022, we had that 8 inches of heavy snow, and our cars were damaged as a result of large oak limbs that fell on especially Ellen's automobile that was parked right where the carport is. I parked, just adjacent to that. So that was the original reason. We were wrong in not getting a permit and it ending up being within 200 feet of the ordinary high water mark. I just appeal to the board that, that hopefully there's a gray area, not just right and wrong. We didn't, our estimate, our opinion is we didn't do any harm to the environment. The neighbors can't see the structure. It's away from the bluff line. It's not visible from the water. And we didn't tear down any trees to construct it, have it constructed. So that is our appeal to the board. If we are required to remove it, the worry is that it'll cause erosion into the drainage field, further erosion toward the drainage field. And we likely won't build another structure. In regard to that area that Mr. Chair noticed where there's, a flat area, the pictures don't really illustrate, and I don't know if Mr. Chair walked up our driveway. We weren't notified if you did, but I don't think it's an exaggeration that this is a very steep drive. It would be hazardous in the winter for us to carry items from our automobile from down at that lower area to walk up that drive. We've had snow plows that actually got stuck on the driveway because it was so steep and slippery.
Thank you. Yeah, it's a steep driveway. I don't think I'd drive up it myself if the conditions were at all slippery. I'd park down by the street and walk up, which is like the public street that I live on has 2 10% grades. And we have had, over the years that we've lived there since '79, we have had a number of times to park at the foot of the hill and walk up, carrying our groceries, carrying our children. In fact, when they were little, I don't know how you see it, but I would think that I would not want to be parked in where your garage is located there and then have ice fall overnight. I'd figure I was stuck for the duration, wouldn't be able to get out of there. Now I noticed there are sand barrels. There's a sand barrel right near your driveway, so that's how people deal with that on Black Bass Road and presumably on your driveway. You got to carefully walk down and then put some sand out there before you drive. And if you're coming home to slippery conditions, presumably you park and you spread some sand and then you walk your way up. But why not use that area that you marked for parking? Put her right there when it's slippery conditions. But you mentioned about the building permit, and I've really been thinking about that since we had our last meeting. Did you apply for any kind of building permit at all? I'm not talking about the Riverway regulations, but did you go to the town hall and ask for a permit?
We were ignorantly relying on the construction.
contractor.
The contractor.
We had a contractor who did not, we assumed he was telling us what to do about any permits. And it turned out that this contractor is probably a serious criminal. We reached out to a lawyer and they said that this particular contractor has a whole list of people that are being investigated, including and so, well, I won't get into that, but it was, we did send a request to the Wisconsin Department of Agriculture, Trade, and Consumer Protection as part of their investigation. That's what we were recommended to do, that apparently they're, anyway, he's a crook.
So you've been to a lawyer, you're thinking of doing something about getting him to fix this situation for you?
Correct, but we're expecting, according to the lawyers that we've talked to, that we would unlikely get any compensation from that fellow. But,
Did he have an insurance? Did you see his insurance
everything he
certificate?
claimed is not true. Everything he claimed did not happen. So no, we don't have insurance from him.
And we're evidently far down the list of complainants, so he would, if he reimbursed, you know, the amount that he's being sued for, he wouldn't have anything left to reimburse us. We've also been able to, you know, drive up our driveway with our particular vehicles and drive down, and therefore it's much more safe to walk from the carport to our house rather than navigate up the steep drive.
Yeah, I would not walk up and down the end of the driveway in the snow or ice. I would never do that. That would be very dangerous, actually, on our property, and we know that from our experience, so.
And yet, a snowplow got off or got stuck.
Well, like I said, the snowplow got towed because it was so bad up on the top of our driveway.
He was at the top.
And he couldn't get out. It was so difficult up there at one time. That was just one really bad winter.
And was the snowplow operator unable to walk on your driveway? I'm not
Nobody was walking on the
taking your
driveway.
point there.
It was difficult. It's just a
Sure.
difficult place to drive.
This is Wisconsin.
But it's winter too, and, you know, it's.
We have winter. Oh, do we have winter sometimes?
I slid on my backside during that particular event, and, you know, I'm pretty agile, but I just slid right down on my back.
So I would like to say, I mean, in this situation, you know, we take the ordinance and the laws seriously. However, our request is that we can, you know, consider doing the opportunity to make this better. We really want to fix it, and we didn't really have an opportunity to do that. We did make a mistake by not getting a permit. We assumed that the contractor would take care of it. Well, that was naive perhaps, but it's what happened, and that's what we knew what to do. And I think in this situation, we're going to cause more damage to destroying this, this structure, this carport, than it would be to keep it as is. And as you saw when you were, I'm glad you came to our property to see what it looks like. And if you could see that where our home is on the top of the bluff. And it's downhill from there. And that on the other side of the house, there is nothing that would have been done by this carport would affect the St. Croix River in any way, shape, or form, because it's going down the other direction, and it's going downhill down the other direction. And we have, you know, we've talked to staff about different ways of trying to improve the property because of the contractor, and then the bad work they did, and then the retaining wall collapsed, and all this. We want to improve the vegetation and make sure our septic system works, and
Change the color to a
change
neutral.
the color, yes. And we want to do all of these things to make it better, but we've been waiting, we can't, if we don't have an approval, it won't be, that would be a hardship for us financially to be able to do any more. So we're in a difficult place. I understand the law wants us to have other kinds of really difficult hardships, but those are the hardships that are facing us. That would make it, we got kind of stuck in this situation.
How do
We're
you-
not getting any younger, so the idea of having to not be able to walk out of our house and get close to a vehicle is very daunting and dangerous for us. That's my concern.
I don't recall if I said this in our previous meetings, but we, the Board of Adjustment, don't make the law. We only apply it. The board, the county board generally makes the ordinances, and some of the things are set by state law. One of those requirements is that when we're dealing with an after-the-fact situation where there hasn't been a permit before the construction starts, we must operate as though the building had not been built there or the thing had not been. We must consider it as though it were a fresh question. Would we approve it before the construction started? Would it meet the standards of the law before it started? The fact that you've already built it is neither a for nor against that we are allowed to consider. The same thing with your personal circumstances. Your age, for instance, or your agility are not factors that we consider. Your choice of vehicles, whether you have four-wheel drives or two-wheel drives, or whether that kind of thing is something we have to put out of mind somehow when we make our decisions, because if you think about it, you realize that the law wouldn't work if we were allowed to base our decisions on the people who are before us. Our decisions are usually perpetual, and so you'll be succeeded by somebody else who will take over that property, somebody who may be nicer than you or worse than you, somebody who will be wealthy or somebody who will be poor. Those cannot be factors that we are allowed to take into consideration. I say that not to be harsh, but to tell you why in our decision document, however it is, you won't find any reference to your age or your agility or your personal choices to live this way or that way. If I remember right, you told us, Ms. Anderson, that you had owned this property for 10 years before you decided to put the garage in. And during those 10 years, you parked your vehicles outside. And we heard from Mr. Lopno this morning that there was a storm that caused a tree branch to fall on your vehicle and do damage to it. Have I got that right?
Correct. If I can speak for Ellen, we only started living there permanently a year and a half ago, or perhaps coming up to 2 years.
A short time ago.
So we didn't live through the
winters.
Ellen
No,
never
I
lived there
lived
during the winter.
So you used it as a summer place, a three-season cottage or whatever kind of thing for most of those years, yeah. So you probably didn't get to experience our Wisconsin winters.
Well, we got Minnesota winters, which are pretty warm.
Which are
pretty cold.
comparable, aren't they? Yeah.
But not quite the same as Wisconsin. I think I guess the only other statement I would make about this is that, the wild and scenic rivers is something that I think is so important, and I support it, and I'm an advocate for it, and there's a lot of reasons for why this ordinance has been created the way that it has, and that the rules are the way they are for the St. Croix River, and I support those things, but I also think that the public interest is about protection of the river and protection of the environment. That's what it's there for, and I think we have a case to say that yes, we made mistakes, yes, we didn't follow the rules, and those are true, and however, the project that we created and the work that we've done is not something that would be against the public interest, in my view, because it wouldn't cause any harm to the river, and it wouldn't create any harm to the vegetation in that area, except that we are trying to preserve our trees as much as we possibly can. And
There was no destruction to the bluff.
so it just feels to me that, the public interest and, the purposes of this are also things that should be considered within the law. And it's clear that, the DNR did not, look closely at this situation.
You say it's clear the DNR did not look closely at the situation?
Well, they didn't look at this exact situation, that obviously they know what they're doing, but it was pretty clear from their.
So you didn't see them when they were there, that's what you're saying?
No.
Yeah, okay.
Did they come there?
I think so.
Huh.
Really?
We had not heard that they had come here. They didn't come with your staff that we were aware of. So.
Well, just the wording that it was within the 40-foot bluff line, it's outside the 40-foot
Well,
bluff
yeah,
line,
in
so we were
Pierce
assuming
County.
they didn't arrive.
Yeah, it seems like they didn't actually. It was
Seems
sort of
like they,
boilerplate.
they need a proofreader, don't they?
I'm sorry?
They need a proofreader, maybe.
Yeah, and I'm not here to, have any negative, opinions about the DNR, just to say that I think it's true that this particular project is not one that is harmful to the environment or to the river. And so we would ask for the ability to have some opportunity to fix the problem that we created.
Well, how would you, if this were approved, how would you deal with the color issue?
We would paint the whole darn thing.
Yes.
Would you
Neutral.
repaint the house too, to match it
Well, if
then?
we had to, we would definitely paint the carport because that turned out to be a brighter red than it should have been. But
So you'd do what this board required you to do and nothing more?
Well, we would do exactly what the board would require us to do.
Correct.
We're not looking to have incur additional expense of painting our house, but if that's what the board recommends, we would certainly do that. And there'd be vegetation, there'd be a gutter, and there would be downspouts, and we would, contract to have it, the retaining wall built much more sturdy with a reputable construction
Yeah.
company.
Yeah.
One the same company that we used for the landscaping, sorry, I'm blocking on the word.
You had a company do some landscaping, you said?
Sorry, that's not right. Surveying,
The survey.
Oh,
company you're talking about,
Ty
yes.
Dodge and his
Yes, and
firm,
they're-
yeah.
correct.
We trust them, yes.
Yeah, they should be able to recommend somebody who's done work in the Riverway before and knows that there are not many places in the United States of America where you can build a garage without getting a building permit first.
We understand.
Board members, do you have any questions for Anderson or Lochno?
Do you live here for the most part? You live in this residence year-round?
We do, and that's been our plan for all the way until we retire. We intend to live there for the rest of our lives. We sold our house in Minnesota a couple years ago.
Any other questions for the applicants and owners? Okay. Anybody else in the room who wants to speak to this application? Okay, did you sign in? All right, step up to the microphone and identify yourself.
Mr. Chair and members of the board, my name is Jan Kusha. I live at 132 Skyline Drive in the town of Troy, St. Croix County. I live maybe a mile from the applicant, although I speak today not necessarily as a neighbor and not as official town of Troy representative, as many of you know I am. I speak as a private citizen with an interest in seeing that the special rules of the St. Croix Riverway that bless us with this western border to have a national park are adhered to. I want to remind the board, as you're well aware, but I want to, I guess, reaffirm that this is an after-the-fact permit. Not only did the applicant not get the proper permits from the county for being in the Riverway area, but they did not seek a building permit from the town of Troy. If one were to accept that maybe they didn't understand there were cause living right next to the river with special rules, if they didn't understand that, certainly the reasonable person would assume you would need a building permit before you could build a garage. I would further argue opposite of what the applicant has in terms of the public interest. Obviously, you board members have to take into consideration the public interest. That's one of the 3 tests. And if you fail any of the 3 tests, you can't grant the variance. I would argue that approving this variance harms the public interest. You would be sending a message to other landowners out there that you can not get your permits, build what you want, take your chances, you probably don't have to tear it down. That sends the wrong message. That harms the public interest. So I feel it fails that test. You have a letter from the Wisconsin DNR that talks about the other tests, which it says it fails. So based on that, I would certainly urge you to follow the comments from the DNR and deny the variance request. But mostly I rise today to make sure that the board is aware of a legal decision that happened in this very courthouse on a riverway. And I'm going to read from that, but I do have copies for the members if I could distribute that.
May we see that?
Yep.
Give a copy to the applicant, and
Yep.
any others you have, Julia's taking. What do we mark this? Exhibit number 1, I suppose?
I'll wait till you have your copies, and I just want to read a couple of portions of the decision by Mr. Waterman and conclude my remarks. So what you have is the State of Wisconsin Circuit Court, Wild Rivers Conservancy of the St. Croix and Nantacoggin versus the Board of Appeals for the City of Hudson. The decision looks to be dated February 29th of 2024. If you start at the last paragraph, I'm going to read Wisconsin Statute 3027, the enabling legislation for NR 118 curtails the power of local government to grant variances from NR 113 standards. Turning the page, the statute expressly prohibits zoning authorities from granting variances from NR 118 standards without the consent of the without the consent of the Department of Natural Resources. You go down to past the bullet points. The DNR did not consent to these variances. In fact, the DNR recommended the board deny them. Without DNR consent, the board lacked the authority to grant the variance. I would argue, based on this legal fact finding and the letter that the the Wisconsin Department of Natural Resources sent, that you would not have the authority to grant these variances. I know you have a difficult decision. I've been in elected office for many years. They're not easy decisions to make, but there are rules for the special requirements being in the riverway. They are to protect that river, not only for us, but for generations to come. And I would urge you to follow the DNR recommendations in this case and, in fact, in all future riverway cases. And with that, those are my remarks.
Questions for Ms. Kucha, board members?
Yeah, what's the procedure for filing a building permit with the town of Troy?
They just call up our building permit, it's listed on our website, and you go in and apply.
Does the town board review them at all, or is it just a paperwork drill?
The town gets the building permits after the building inspector has approved them, so they go straight to our building inspector. And if they, in this case, had they come to the town, our building inspector knows that this is a riverway property with special rules, they would have referred them to the county. In fact, I do believe they got a letter from our building inspector saying they needed to come to, that they didn't have a permit from us and that they first needed to come to the county.
Does the, normally, do you get the request for building permits from the contractors a lot, or usually from the homeowner?
You'd have to ask our building inspector that. I don't do that. I know as a person who has done various projects, if I ask the contractor if they're going to do it or should I. If the contractor says they do, I actually will call up the building inspector and confirm that it's been done.
Now, we're gonna put all that out of our mind when we decide on this, because we have to treat this as though there were nothing there and this were an application before the fact. But I can't help but wonder, a lot of towns have a little sign, I think they're a standard sign that you can buy from some supply house or something that says permits are required, or in my town, the town of Hudson, I think it says all permits required, which implies that things, not only building permits, but maybe picnic permits or liquor permits or other. Does Troy have signs like that around your borders that say, that give people hints that a building permit would be required?
My understanding is we do have a sign to that effect, but they aren't on all roads leading into Troy.
You got some, but not on every road, did I understand you right?
I believe we have one.
Oh, one, I see. So it depends on which direction you come from.
That'd be correct.
Okay. Well, we're going to ignore that when it comes to making a decision anyway, but in the interests of future situations and whether we establish a precedent here that, as you say, might encourage people, other people to avoid getting permits and then come ask for pardon later. There's some saying that goes like that.
Correct. And my main focus is really this decision and the role of the DNR and what authority the boards have, and that you are well aware of that as you enter your deliberations.
Yeah. More questions for Ms. Kucha?
Not for her, I do for the applicant, though.
Oh.
All right.
Okay, thank you for your testimony. You have a question for the applicants, Mr. Peterson?
Yes, I'm just curious, did you have any kind of a contract, signed contract with this contractor that indicates that he should or would get this permit application just for so it's not he said, she said?
No, there was definitely, documents. I have to look at it and see exactly what it said, but yes. Definitely had a contract with him.
Do you want to what? Oh, yeah, sure. I gave it mine to Steve. Yeah, you're welcome to it.
Well, while Ellen is looking for the contract, so thank you, Jan, for this document. Only part of the document was read, and on page 3 there's a few appeals that did not require DNR approval, and then on page 4, paragraph 1, The board has discretion when determining whether a variance request should be granted, but the board may do so only when compliance with the strict letter of the restrictions governing area, setbacks, frontage, height, bulk, or density would unreasonably prevent the owner from using the property for a permitting purpose or would render conformity with such restrictions unnecessarily burdensome. So there are exceptions to the DNR position based on appeals.
There's definitely something here about permits. I'm sure there is. I know, I'm reading it. It's very important.
Are you having success finding the contract?
I have it,
Found
and
it.
I'm pretty certain it says something about that, but I'm trying to find the words. It's a long, wordy contract that he gave us. It's meaningless to me, unfortunately.
So did you find the place where it says he's going to apply for a permit?
Still looking. I believe he said something about that, but I'm not sure. If you don't mind, we'll find it.
I suppose we could maybe cut to the chase. When you consulted your lawyer, did your lawyer look at that contract?
The lawyer recommended that we don't even try to help get involved.
Was
So-
that because you'd be in a long line of other people seeking to get recovery? So,
From that particular contractor, yes, who's being,
Yeah.
investigated by the,
but before he got to that point, did he say you had a good case? Except for the collection part of it.
we didn't get to that. We didn't get to that.
I see, yeah.
He did recommend that we forward all this material to the Consumer Advocacy Department.
Oh, yeah.
in Wisconsin.
Have you had any response on that yet?
Not yet.
How long's it been?
One week.
I see.
How'd you happen to choose this contractor?
Through a third-party referral source, the name of which I don't recall.
We've got the name and address in our file, I know. And I didn't recognize the name. Oh, E. Stephen Moncada, 949B Manette Avenue, New Richmond, Wisconsin.
As soon as we said that name to both the attorney and I think it was the Consumer Advocacy Group, they were well aware of his shoddy work.
Where is it? Yeah, it's somewhere in, yeah. I'm not 100%.
If I could maybe get a copy of that.
Would you mind providing the staff a copy of that contract for our
Sure,
records?
absolutely, yeah.
At Mr. Peterson's request?
Mhm.
Yeah.
How would we do that?
Well, we're gonna, I guess I don't see how that's allowed to affect our decision anyway. It may have a lot to do with whether you can get any relief, or you can get this guy to move your building if that's required, or to repaint it if that's required, or whatever. may have to do with that, but it probably doesn't affect the decision of this board on whether or not to grant the requested variance to the 200-foot setback. Any other questions, board members of staff or any of the other witnesses that we've had here? So, okay. In that case, it's now just about 10 o'clock, 9:59. I will close the hearing, I think, and we won't, I can't anticipate that we would want any more documents or stuff. Julie, you can follow up and get a copy of that contract into our files. This is the sort of case that may well end up in the courts upstairs, so let's give the judges the best possible record that we can to work with. Let's see. So as we left it last time, did we take a motion or was it just kind of a sense of the room? I don't know.
Take a motion, I remember.
Do you have a proposal for us, Jason?
Yeah, so at the last meeting, the board took and postponed any decision because they directed staff to create findings of fact and conclusions of law and come back with some conditions if the board was going to approve of the request. And so that is what we've got here, is some updated findings and conclusions that would ultimately support the request, because we didn't have any DNR feedback, because the DNR took almost, or right around 2 months to provide any comments. Would you like me to go through the findings of fact that we've got on this application, Mr. Chair?
I'm looking for it here. Is it in our packet?
Yes, it was right behind the DNR letter, and that's the one I.
Find the DNR.
Ah,
Yep.
I thought I'd seen it.
There you go.
Yeah, go ahead. This
Okay,
is,
so
this is
finding-
leading to the conclusion of granting the variance, right?
Correct, and that, so the findings of fact that we've got are the property owners are Ellen Anderson and Robert Wapnow. The site address is 122 Black Bass Road, River Falls, Wisconsin 54022. The applicant filed a completed application to request a variance to locate an accessory structure, or what they refer to as a carport, within 200 feet of the ordinary high water mark of the St. Croix River. This is an after-the-fact request. The structure currently exists, and it is located approximately 168 feet from the ordinary high water mark. The carport or structure is approximately 20 feet by 24 feet in size, for a total of 480 square feet. The carport is located at the 40-foot setback line from the bluff and is within the 100-foot normal setback line from the bluff. The carport is not visible from 200 feet riverward of the ordinary high water mark and is visually inconspicuous from the river, so that is
You want us to
correction.
modify that?
Yes. The carport is red and not an approved earth tone color, which is a requirement to be less than the 100-foot setback from the bluff line, so that it would be a requirement. The carport is not within a slope preservation zone, which a slope preservation zone is any slopes that are greater than 12%. Comment from the town of Troy was not received prior to the hearing, even though today we had some public comment from a town representative on the town board, but those were personal comments. Number 11, the DNR has submitted comments to the department, so our community development department, on August 19th, 2024, stating they do not believe the applicant has met the 3 variance criteria. That letter doesn't come out and exclusively deny the application, like the court case refers to. So then we got to look at the 3 variance criteria that the Board of Adjustment has to consider for granting or denying of any variance. Unnecessary hardship. We think the property does contain other compliant areas where an accessory building could be built. However, the applicant's request is dictated by the location of an existing dwelling, and I will add that that is a non-conforming dwelling. and the topography of the site. In the winter season, the terrain could be difficult and challenging to navigate on foot between the house and a compliant accessory building location, as the applicants have laid out today in their comments. And an accessory building is an allowed use on the property, and the size of the structure is modest, because part of the unnecessary hardship is to have a structure that meets the minimum requirements to meet the allowed use of the property. Any questions on unnecessary hardship before we move into unique property limitations?
It's a three-car garage, right? 24 by 20.
20 by 24, and that, usually I would only consider that a two-car garage. So by the time you have some rooms to open up car doors and stuff, so usually a 16-foot wide garage door is only suitable for two cars, and then you gotta have a little bit for your framing on the sidewalls, you know, and that to actually put the tracks on and stuff, so anyway, so that's about 18 to 20. Depends on what size your car is, though.
So, two-car garage.
Yep. One could argue in that you might only need a one-car garage, you know, too. So, I mean, that's up to the Board of Adjustment to make that call. What is the minimum relief needed for that allowed use? Unique property limitations. The property is composed of a steep bluff line to the west and a closed depression area to the east. The other compliant location for an accessory structure on this property creates additional challenges. Placing the structure closer to a neighboring lot line may increase its visibility from adjacent properties, which was also mentioned in that DNR letter and that, to take and try to avoid. Placing the structure further down the driveway would result in navigating up the remainder of the steep driveway on foot to the dwelling, which they've mentioned in that as a challenge during the winter months. Relocating the structure east is not a viable option, as the property's septic drain field is there, so that'd be directly east from the current location. So that means that it's got to be pushed to the north towards that other property owner, which would be more visible to them. The only other compliant spot on the site would result in removal of several large trees, and the water drainage would likely become an issue because it would drain from the house and that back through that new building towards that closed depression, or I'll call it a low spot where any storm water probably collects from that property to the north, because it looked like they had a pretty good sized dwelling close to the lot line as well.
In my opinion, and I guess I'm one of the few who's seen the property, that place where they had designated the parking is a potential location for the garage. I'll just note that for the record.
Okay. The third criteria is not contrary to public interest, and the carport structure is not visible from the river in its current location. From the top of the bluff line, the parcel drains away from the river to the east into that closed depression or low spot on the property. The threat to the surface water or groundwater is very low due to the drainage of the parcel. Moving the structure from its current location would not address the existing erosion issue and would create another one potentially. Could also potentially create more hardscape. If the shed was moved, several large trees would also have to be removed, and it would be visible from the neighbor's property. The applicant will need to demonstrate with the submittal of a land use permit that all other standards for structures have been met to be within that 100-foot bluff line setback.
Again, I will state for the record that that designated parking area could be a location for the garage that would not require removing large trees.
Okay. So then, section 17.70, parentheses 6, parentheses E of the St. Croix County Ordinance states that a variance shall not grant, extend, or increase any use prohibited in the zoning district. And accessory structures are permitted uses in the riverway overlay area if constructed in conformance with applicable standards. The existing structure is not in conformance with the applicable standards. However, the structure color and stormwater and erosion control can be managed. The second provision is be granted a hardship based solely on economic gain or loss. The request does not appear to be based solely on economic gain or loss, as the approval or denial of the request will not change how the property is utilized. The third one is be granted a hardship which is self-created. The existing house was constructed prior to the adoption of the Lower St. Croix Riverway Overlay District, and the applicant desires to place an accessory structure within reasonable distance of the house and in a location which does not pose additional challenges due to topography and neighboring properties. The fourth one is damage the rights or property values of other persons in the area. Granting of this variance request does not impact the view or create possible contamination to the river or other parcels. Provisions 3 and 4 in the ordinance are not applicable to this variance request because there's no amendments to the ordinance required and it is not a historic structure. So going off from the BOA's previous guidance, staff said that the Board of Adjustment would approve or could approve the Anderson-Wapnow variance request on the basis of the findings of fact and conclusions of law above with the following conditions. And so number one is all components of the structure shall be modified to earth tone colors approved by the Community Development Department. And our department would be using the earth tone colors approved by the Lower St. Croix Riverway regulations. Number two, the owner must stabilize disturbed areas abutting the structure and provide stormwater management of runoff from the structure and associated impervious surface. So what we mean by that is they would actually have to capture all of the stormwater off from that building and off from the hardscape around there, and that versus if they do put it into a compliant location, and that we would not have that requirement, and that so we can actually offset some of the public interest with the additional runoff by making sure that we retain that water either in a subgrade infiltration pit or a rain garden, that kind of stuff. So that's a requirement that we can go above and beyond. Number three is another requirement that would be above and beyond if they just built the structure in a code compliant location. We're saying that the owner must establish native plants around the structure completely via an approved plan by the Community Development Department, so that it's not just Kentucky bluegrass, that we are getting the native plants and that to help stabilize that area and to help with the water capture of the site. Then we get in.
Why do you say that's above, the 2 and 3 are both things that we always require?
And that, but if they are in a compliant location where there's a variance that's not needed, they are not required to do 2 and 3.
Right, but this is a variance request.
Yep.
We always, in variance requests,
I was just
require,
pointing out and that if you have a variance that is granted in this case, we can actually be more restrictive or put some more restrictive requirements on it, like the stormwater management and the native plantings around the building, versus if they were to build at the compliant location and we weren't before the board, they could plant Kentucky bluegrass and there would be no requirement to capture the runoff. It would be able to drain across the landscape. So. Number 4, the applicants must obtain a land use permit from the Community Development Department. Number 5 has been talked about a lot. The applicant shall secure all permits and approvals needed from the town of Troy and obtain any other state, local, or federal permits and approvals. Number 6, and that is the applicant shall have 1 year from the issuance of the permits to complete all the required modifications to the structure and the site improvements. And failure to do so would result in revoking of this variance and they would end up removing the structure. Number 7, in case the property changes ownership, all the new property owners that might own the property in the future must adhere to the standards and conditions of this variance approval. And number 8, and that is just a general condition that the applicant understands by signing this application that they are going to comply with the conditions and have no objections to county staff being on site for frequent inspections. So that is what staff came up with the previous guidance and that from the board.
So we only got the one typo in the findings of fact, number 7. A finding would be that it is visually inconspicuous, and that's because it's hidden behind the bluff line.
Yes, you're correct. That was a typo.
I suggest that if this is approved, the applicant should also be required to repaint the house to a compliant color as a condition of the approval of the matter. And
Question,
if they choose to appeal it, we'll take on the appeal. Mr. Telejohn?
is there any fines for building this after the fact and not having a permit? But you-
Correct, and that, so they paid the after-the-fact variance application fee, so that would be a penalty of $2,300 already, and then the land use permit application, and that would have some after-the-fact fees as well.
So all fines and fees have been paid or will be paid?
And that, so all the fees for the variance hearing here have been paid, so that was a total of $3,450. And then there'll also be another $800 in penalty fees for the land use, plus the normal $400 fee, so there'll be another $1,200 for the land use.
Okay, thank you.
There is a finding that
And
this
that-
is after the fact, and the structure currently exists. It's number 4 in the findings section.
And because there's gonna be some significant staff time reviewing, and that the erosion control plan, the stormwater plan, the vegetation plan, so that's why that land use permit is really needed.
Sure. That was established by the county board. It's not discretionary to us to do it or not do it.
So our normal violation penalty is 2 times the normal permit fee, that's the violation fee, and then that's in addition to the normal permit fee. So it's kind of a sliding scale, depending on what kind of violation they got, the penalty fee would change with that.
With reference to the conclusion of law, no harm to public interest. The person that brought this to the attention of the town board, was that a complaint or was that just an observation?
I am not sure in that, how that was stated. I believe it was just that there was a new structure being built, and that they didn't think it complied. So that's how our staff got it and started following up on it, I believe.
I'm wondering if we're maybe not on thin ice by requiring the house, which is grandfathered, to be changed. I'm curious, Corp Council might have a comment on that.
Oh, I think we are on thin ice, and if the applicants chose to appeal, that would be just one way of litigating about this variance. I mean, it's very likely that if this is approved more or less along the lines that are here, somebody in the great wide public is going to appeal it anyway, because the DNR letter says there's no hardship, it's not unique. And of course, this board has the right to do what it does, but that's what courts are for.
Mr. Chair, I can add, that the applicants on the record today have stated that basically out of a goodwill faith, they don't want to paint the house, but they would potentially consider that to take and help with the situation. I would just caution the board about making that a condition on the approval for the garage, since the house is a non-conforming structure in color or in size or location. That's a totally separate matter. If they want to do that in good faith and that, it might look good. That's kind of what they've agreed to today here on the record on that. However, our conditions should be just for the conditional use permit application on the accessory structure. That would be my advice.
Yeah, well, I hear you, but they said they would do what was required and nothing more. So, require it. If you want to, you want to thumb your nose at the DNR, then get something for it, the changing of the house color. So, we're at a stage here to take a motion, and if you're, the way we normally do these things, the staff recommendation becomes the framework, and we modify it if we see fit. I would suggest that it be denied. That's, my personal opinion on it, because I happen to agree with the DNR and Ms. Kucha. But if the motion is going to be to approve it, then I suggest that the motion include repainting of the house. Number one is not just say all components of the structure, but all components of the structure and the house shall be modified to earth tone colors. And having said my piece, you're each independent voters, and I'd leave it to you.
I'll give my thoughts on it, and then we'll see. But, we have a situation where I personally, when I was very young, our first house we built, had a contractor, a reputable one, and just assumed, with all the stuff that's going on, that yes, a building permit would be applied for. And next thing I know, there was a red tag in the house, and there was no building permit requirement obtained. So I can see how that can happen, I guess. And yes, we have a violation. We have after the fact, but with some help, I guess. So then, if we just look at the ordinance, I don't think we can just, in my opinion, look at it black and white. There are circumstances here, whether it's intentional or not. The building is there, and in my mind, we're probably causing as much or more harm by making them remove it than getting something, as the chair suggests, to make it better. And that's just my thought. I'm leaning toward approving it. I'll leave it at that.
I kind of agree with you, Mr. Peterson, on your thoughts and sentiments also.
Well, does somebody want to make a motion then?
I'll make the motion that we approve it with the addition of with the applicant's willingness to paint the house of an earth tone color also. And also, I'm assuming, Mr. Jason, I'm mispronouncing your name, I'm sorry. But also to make sure that where it came down away from the erosion on that one side of that shed, that somehow, to your specifications, be corrected so that we don't have that situation also going again.
Correct.
Well,
I can
that would
kind of
be-
explain what we would probably want from the applicants for that. We'd probably want gutters on both sides of the roof, and those gutters would then drain into a rock infiltration pit. I'll call it a French drain for common terms, and that which can be either completely subgrade or at the grade surface, so that all that water is being captured, and then that would also keep the water from behind the retaining wall, and that, because that's the worst thing for retaining walls, to take them out. So that would be one option if they want to build a wall along the east side, I guess it would be, of that structure. Otherwise, they could establish like a 3-to-1 slope, you know, and that with fill, something that is easy to stabilize. But of course, that whole area would be established with natives, and that would be deeper rooting, would take and hold back that soil, and it would also capture any extra runoff that might be missed by the gutters, so.
Yeah, I didn't have any particular suggestion, just to make sure we get it done right.
That's all encompassed in your condition number 2. Is that right, Mr. Chiza?
Correct,
You feel
yeah.
that language is
Yep.
broad enough to include
Yeah.
what you've just talked about with Mr. Peterson?
Right.
Good.
I'll
And our-
second that.
Okay, and, good, thank you, Mr. Telejohn. We have a second. So you're modifying number 1 to include the building, the home in the painting
Yes,
requirement?
yes. And I guess we could just mention as offered by, in goodwill by the applicant.
Structure and home as offered by applicants. Okay, we have a motion, we have a second, we're ready for the vote. All those in favor, vote aye.
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 All those opposed, vote nay. Nay. So the motion carries. And I do not require that the record record my nay, but if it does, I'm not opposed to that either. That, I think, takes care of that item of business then. After the signing of the decision, there'll be 30 days to appeal, as usual.
Yeah, you'll get mailed a copy and that, so. Yes, if you want these. So here, I'll give you my copy of that, so the only
Do we have any discussion about next meeting? Or other interesting topics to talk about?
sounds good.
Just
You
your
bet.
report,
Yep.
unless Jason's
Please
got
be in
something.
touch in that with Kelly and Mike and that as far as going forward, so anyway. Yep, it's important to get it done correctly, quick, so, yep.
Okay, anything else you'd like to talk about?
Oh, sir.
Discussions for next week? There's one thing I'd like to talk about. So I'd like you to put it on the agenda for the next meeting. We'll see if we can get to it and think about it. We used to have a practice where the staff would prepare a potential decision document and would include it in the meeting packet. In the last 6 or 8 months, the staff has moved from that practice to a practice where they prepare a decision document but don't hand it out generally to anybody until the day of the meeting. So it comes as a surprise to the board, a surprise to the applicants, a surprise to the public. It's not part of, it's not available at the website. And I think there are pros and cons to this practice, but I'm a little inclined to think it is better to make it all available in advance of the meeting to anybody who's interested by having it be a part of the packet. So if we could review the pros and cons of that at the next meeting, Jason? I take it you're open to that kind of discussion.
Can we do it at the October meeting, and that's that I'm here for that conversation?
Oh,
Because I
sure.
will take complete responsibility for that change, because the reason why we have the Board of Adjustment and we go through all the public hearing and public notice, and that is really, and that to take and have due process on these applications so that we're not having predetermined outcomes. And that I've actually had issues with that in my past. And so literally, I was making comments during a hearing, and I know we're getting off topic, off the agenda.
Well,
and
yeah,
that-
let's not
but-
really, let's not talk about the merits any more than I
So-
did to introduce the subject and suggest it be on the agenda. For now, we'll have a thorough discussion then.
Okay. If we
There are
can-
certainly pros and cons about it, and you may want to weigh in too, Heather, and that's just fine.
Yep.
But let's schedule it for October then, when you can be
Okay.
here,
Will do.
and that's fine. Anything else we should talk about before we depart this vale of tears? Thank you all. This, I know we're dealing with some toughies here, and I appreciate your hanging in there and being willing to look at all the complexities of life. With
What
it.
is the real meaning?
What is the real meaning of life, says Mr. Peterson, and, in 25 words or less, I suppose you mean? Yeah. Thanks for being here, Heather, and lending us, I didn't realize, I worried we were putting you on the spot. Of course, we were putting you on the spot. And if you had to say, I need time to think about that, I mean, you must always feel empowered to do that, you know.
I hired her, I expected her to hold it in the ice.
Are you taking all the credit for her being our corporation counsel? We are
Most of it.
extremely fortunate, I get around to other counties sometimes and I talk to other boards of adjustment, and we are extremely fortunate to have a lawyer at our assistance here who not only knows the subject, but is responsive to the board, If you had said you wanted this kind of a decision, she'd do her very best to give it to you. If you said, I want that kind of a decision, she'd do her very best to. And not all lawyers have that flexibility. Some, make up their own minds, and you have a hard time getting out of that rut. They want to be the Board of Adjustment. Yeah. So, thanks again.
Thank you, Heather. We really
If that's on the record, I'll stand behind it. All right, it's now reading 10:31, and I declare this meeting adjourned.